war affecting nature anywhere affects it everywhere. Before Russia's aggression, this impact has been largely sidelined as collateral damage. This must change. Russia uses the destruction of the environment as a weapon of war. The consequences are devastating, widespread and long-term. The air has been polluted by over 10 million tons of combustion products.
В повітря забруднено 10 мільйонами тонн хімікатів, 20% сільськогосподарських вугіль не підлягають подальшому висториканню. Агресор б'є по ядерних об'єктах. Зруйнування Каховської дами – найбільша катастрофа в Європі після Чорнобиля. І це лише одна з 92 атак на об'єкти водної інфраструктури. Виклики мають глобальний характер. Ми мусимо об'єднатися. Україна – перша країна, яка притягуватиме до відповідальності за екозлочини і екоцид. Міжнародні експерти працюють пліч-опліч з українськими слідчими. Наша ціль – створити прецедент і захистити довкілля. Заради народу України, заради людей усього світу. Світ має навчитися працювати разом, а то нічого не буде робитися взагалі. 2 days an hour.
Ladies and gentlemen, we have reached
Пані і панове,
session number 8 of our summit.
восьма сесія.
Lesson learned and emerging
Вивчені уроки та нові шляхи відповідальності за шкоду навколишнього середовища. Модератор Ендрю Карні. Керівник управління прокурорських розслідувань міжнародних злочинів місії ЄС. Вітаю всіх учасників 8-ї сесії цієї важливої конференції, де ми обговорюємо практичні механізми та рішення. На цій панелі ми будемо говорити про вивчені уроки та про можливі нові шляхи, притягнені до відповідальності за заподіяння шкоди довкіллю під час війни. Дозвольте представити наших панелістів. Перші 2 спікери, однак, виступлять в онлайні. Це буде Лорд Ахмат Вімблдон, спеціальний представник прем'єр-міністра.
the Foreign and Commonwealth and Development Office of the United Kingdom. He's also the Prime Minister's Special Representative for Preventing Sexual Violence in Conflict. We shall be hearing from Jojo Mehta, who will deliver an online statement as well. And Jojo co-founded Stop Ecocide, along with legal pioneer, the late Polly Higgins, to support the establishment of ecocide as a crime at the International Criminal Court. She's the convener of the independent expert panel for the legal definition of ecocide. Thirdly, and I now move to the live panelists who are here this afternoon, we shall hear from Kate McIntosh, who is the Executive Director of the UCLA Law Promise Institute, Europe. And Kate has extensive career in human rights, humanitarian law, and international criminal justice. And in fact, from 2020 to 2021, Kate was the Deputy Co-Chair of the Independent Expert Panel for the Legal Definition of Ecocide. Sat next to Kate and in the middle is Carl Brook, who is the Director of International Programs at the Environmental Law Institute at the founding president of the Environmental Peacebuilding Association. Now, Carl has worked on environmental consequences in war for over 25 years. And we'll also be hearing from our Fifth esteemed panelist, that is Nabil Ahmed. Nabil is the founder and co-director of Interpret, a research agency that pursues environmental justice through spatial and visual investigations. For over 10 years, the team that he leads, which includes architects, filmmakers, researchers, and developers, have conducted research and investigations on the environmental destruction and human rights violations resulting from extractive projects, nuclear tests, and conflicts in Indonesia, Brazil, Nigeria, Poland, Norway, and French Polynesia in legal and advocacy contexts. Nabil is a professor of visual interpretation in the Faculty of Agriculture and Design, Norwegian University of Science and Technology, Trondheim, where he leads the Norwegian Research Council-funded project Climate Rights, designing visual evidence for climate cases. He and Interpret are working closely with the Climate Council on assisting the Specialized Environmental Prosecutor's Office of the OPG in pursuing criminal accountability for environmental war crimes in Ukraine. So before we turn to the questions and the speakers, can I just say just a few general comments? Obviously, the last decades have seen a steady increase in the efforts of lawyers and environmental activists to strengthen the legal framework so as to protect the environment from destruction during wartime. The scale of harm that has currently been inflicted on Ukrainian towns, the countryside, forests, seas, and watercourses is quite staggering. We're all familiar with the footage of fields and forests littered with craters like a plague on the once pristine Ukrainian landscape, and the tragedy of the fertile agricultural land that once fed the world, now saturated with mines and other munitions. Just another example of the havoc wreaked by a cynical Russian leadership that cares nothing for the natural environment. So some key questions that come to mind. Which international laws can be relied upon to protect the natural environment during armed conflict? And who is responsible for their implementation and enforcement? What steps should and can be taken for the expansion and application of an effective legal framework to protect the natural environment during armed conflict? Because this is really the challenge, converting environmental harm into international criminal law and other effective legal accountability mechanisms. So let us turn to the panelists. And firstly, we will play a pre-recorded video of Lord Ahmed of Wimbledon, who will give an address of solidarity and support to the people of Ukraine. If we can have the video of Lord Ahmed, please.
Your Excellencies, it's an honor to address this extremely important conference, examining how we can work together to deliver accountability for wartime environmental damage. Tragically, as we've seen in the last few days and weeks in Israel and the occupied Palestinian territories in Gaza in particular, and for over 600 days in Ukraine and other parts of the world, conflict causes untold human suffering, the loss of innocent lives. And the damage goes still deeper and further. The relentless bombardment and deliberate sabotage that we see of Ukraine's infrastructure is taking a terrible toll on Ukraine's land and nature. This devastated environment is a silent witness to the lasting suffering caused by conflict. And this conference offers us an opportunity to work together to find ways to shape our response to the environmental consequences of war. Together, we all, Ukraine, the United Kingdom, our allies across the world, have demonstrated strength and unity in our response to Mr. Putin's unprovoked invasion of the sovereign nation that is Ukraine. Today, ahead of the United Nations International Day for Preventing the Exploitation of the Environment in War and Armed Conflict on the 6th of November, we together can shine a light on the need for accountability, a light on the need for accountability for crimes that impact the environment, and work together to advance our work in this most important field. As we reflect over events, the destruction of the Kakhovka Dam earlier this year was abhorrent, it was shocking, and is still causing untold human and ecological suffering. The flooding of more than 40 towns and villages, Tons of oil, pollutants spilt into the Dnipro River, and crops ruined. Put bluntly, this pollution and destruction cannot be forgotten. On our part, the United Kingdom is helping to ensure that those responsible for these atrocities and crimes committed during the conflict in Ukraine, this illegal war on Ukraine, are held to account for their abhorrent actions. We provide support to the International Criminal Court's independent investigation, and we are helping the Office of the Prosecutor General of Ukraine to conduct fair and effective investigations. May I commend the professionalism, the diligence of the Environmental Department within the Prosecutor General's office for its incredible work in the most trying and difficult circumstances. My message is a simple one and a clear one. We are ready to continue to support you in your valuable work, including through our Atrocity Crimes Advisory Group partnership, working together with our key allies and partners, the United States and the European Union. Our support for Ukraine will not waver. We stand with Ukraine, and I wish you every success for discussions on this key issue. And to all Ukrainian friends across the world and in Ukraine, a simple message from the government: we are with you for as long as it takes. Slava Ukraini.
And I'm sure we're all very grateful to Lord Ahmed for his stirring words and indeed the wider support given by the United Kingdom government. So now we will play a pre-recorded statement also of Jojo Mehta, and the particular point that Jojo will address is the growing momentum for the inclusion of ecocide as an international crime within the Rome Statute, which he has made huge efforts to try and bring about. So if you can please have the pre-recorded statement of Jojo Mehta.
Excellencies, ministers, colleagues and friends, it is an honor to be able to provide an intervention at this important event, and I'm most grateful for the opportunity. I will speak briefly about the growing momentum behind the legal initiative to criminalize mass harm to nature, or as it is now increasingly known, ecocide. There is a large and growing body of environmental laws around the world, as well as an increasing number of multilateral environmental agreements. And yet we stand as a civilization, not at the brink, but already in the throes of ecological collapse, with more than half of the key planetary boundaries for safe human habitation already crossed. Why is this? Quite simply, culturally and historically, we do not take protection of the living world seriously enough in our day-to-day lives, and we underestimate the significance of destroying it. We see environmental damage, if we take note of it at all, as an expected, regrettable side effect of the extraction and disposal of the materials and stuff we have come to believe we need. But without clean water, without breathable air, and, as Ukraine, grain supplier to the world, knows only too well, without fertile soil, we quickly come to realize what our needs truly are. When the aggressor in a conflict destroys these things, as has happened and continues to happen in Ukraine, lives and livelihoods are destroyed, sometimes far into the future and well beyond the conflict zone. And at present, the embedded cultural resistance to perceiving the significance of this damage means that we have inadequate and piecemeal legal provision to effectively address it. This has given a free hand to the aggressor with respect to impunity for what can only be described, for example, in the Kakhovka Dam attack, as atrocity crimes. That this conference is taking place at all is a recognition and an acknowledgement that this must change. The criminalization of ecocide, recognition of the worst harms to nature as serious international crimes, could go a long way to shifting these cultural attitudes, as well as to improving judicial enforceability of relevant laws and providing straightforward, clear, legal recourse for the victims of environmental atrocities, whenever and wherever such atrocities are perpetrated. In recent years, the world has seen a rapidly accelerating interest in this legal initiative. Following the launch of an international definition of ecocide in 2021, Dozens of nations are now talking about ecocide law, with Belgium in the process of legislating, and domestic bills proposed or announced in Brazil, the Netherlands, Scotland, Spain, Catalonia, Mexico, and Italy in just the last few months. The Republic of Vanuatu, particularly vulnerable to the effects of anthropogenic climate change, and of course Ukraine, victim of severe environmental destruction in armed conflict, are vocal advocates. An international crime of ecocide is also supported by the European Parliament, 27 states, currently discussing inclusion of ecocide-level crimes into EU law with the EU Commission and Council. The Parliamentary Assembly of the Council of Europe, 46 states. The resolution passed in January of this year recommending states to legislate for ecocide nationally and internationally was strongly supported by Ukraine. The Parliamentary Assembly of the Organization for Security and Cooperation in Europe, 57 states. The Interparliamentary Union, 179 states. The International Corporate Governance Network, a grouping of the world's top asset managers. The World Council of Churches. The Alliance of Mother Nature's Guardians, a network of indigenous leaders from around the world. Youth, faith, and ocean networks have endorsed the initiative, as have citizens' assemblies and business and investment networks. Our organization, Stop Ecocide International, continues to encourage diplomatic engagement and develop civil society support networks at all levels. For ecocide to be recognized as an international crime, an amendment to the Rome Statute of the International Criminal Court, the ICC, must be agreed and adopted by at least 2/3 of states parties to that statute. From the current pace of developments at national and regional level, we believe this could and should happen before 2030. The most important milestone in this rapidly evolving conversation was the emergence of the aforementioned definition of ecocide as an international crime, proposed by an independent expert panel of top lawyers from around the world, convened in 2020 by our charitable foundation, and co-chaired by renowned international lawyer and expert on the origins of international crimes, Professor Philippe Sands KC. The deputy co-chairs of that panel, Richard Rogers and Kate McIntosh, are with you today in Kiev. Backed by a broad consultation process, this drafting project was completed in June 2021. According to the expert panel's consensus proposal, ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. This definition has been the direct inspiration and basis for the many proposals under discussion around the world at present. By focusing not on particular acts, but on the severity of threatened consequences, this definition avoids a number of political and practical pitfalls. It creates foundational legal support for existing regulation and criminal provision, and has broad applicability to all contexts of severe environmental harm, from climate harm to harm resulting from or inflicted as part of armed conflict, to specific direct harms such as deforestation or toxic pollution. It is also dynamic over time. Indeed, we firmly believe it to represent an essential parameter for the healthy functioning of human societies into the future, and therefore urge all legislators to pay close attention to it. In closing, I wish to specifically acknowledge the political generosity and forward-looking spirit of Ukraine in supporting the development of ecocide as a crime at national, regional, and especially international levels. As new laws are not by nature retroactive, what this crime represents in the context of Ukraine is support for the future and for the international community as a whole. As Prosecutor General Andriy Kostin has said, Ukraine does not wish to see what we have suffered inflicted upon any other state. This is a powerful and moving expression of care for the common good, and one I hope we can all not only align with, but respect and actively respond to. Recognition of ecocide as an international crime will concretely help to ensure that indeed all states have a measure of protection from what has been inflicted upon the people and land of Ukraine. I hope and trust that this weekend's discussions will actively support and help to progress this recognition. Thank you.
So if I can turn to Kate first. You were a member of the independent expert panel for the definition of the new crime of ecocide. Can you give some detail or some small detail of the proposed crime?
Yeah, sure. Thank you very much, Nick, and thank you for the invitation. It's really an honor to be here, and I've been so impressed by the visionary, forward-looking approach of Ukrainian Prosecutor's Office and the Ukrainian people more generally in the middle of this war. So my respect. So as Jojo mentioned, and as Nick said in his introduction, I was a member of this panel, and you can see a picture here of all of the members. It was a diverse group. You can spot Richard Rogers at the bottom, who spoke yesterday, but we were a group of people from Sierra Leone, France, Ecuador, Chile, Senegal, Norway, Bangladesh, Samoa. It included environmental lawyers, activists, a member of the International Law Commission, a former judge of the International Criminal Court, and it was a great privilege for us to work together. So our proposal, as Jojo outlined, was to add a fifth crime to the 4 existing crimes in the statute of the International Criminal Court, and you'll be familiar with what those are, I'm sure. We already have genocide in Article 6, crimes against humanity in Article 7, war crimes in Article 8, the crime of aggression in Article 8 bis, which was added later. And our proposal then would be to add a new proposed Article 8 ter, and this is the text that you just saw Jojo also put on the screen in her video presentation. I'll just try and pull it apart a little bit and give it a bit more depth, because it's quite impenetrable at first glance. And there are just 3 points I want to draw your attention to. So first of all, you may note that it's a crime of endangerment. The criminal act does not consist in causing the damage, it consists in causing a substantial risk of that damage. So if you look to the definition, the acts are committed with knowledge that there's a substantial likelihood of severe and either widespread or long-term damage being caused by the acts. So why did we pick a crime of endangerment? Well, first of all, of course, the major objective of this crime is to prevent these acts. So creating the risk takes the prevention a step back in the chain of causative actions in that attempt to prevent. And then the other 2 reasons are really about the nature of environmental harms, and this was addressed by a number of the speakers yesterday in terms of the lack of total predictability and certainty as to what the exact impact of various acts is going to be on the ecosystems and the biosphere. So first of all, we didn't want for a prosecutor to have to wait for the harms to manifest before being able to proceed to prosecute the crimes. And secondly, we were advised that demonstrating a 100% causal link between acts and the consequences might actually be, in a number of circumstances, too demanding, and that a substantial likelihood of the harm was a more realistic proposal in terms of proving causation. And we also considered that substantial likelihood, knowledge of substantial risk, was a high enough threshold for an international crime. And finally, we were inspired in this drafting by the existing war crime, which we've heard a lot about in the Rome Statute and under Article 8(2)(b)(4), which is phrased as it prohibits launching an attack in the knowledge that damage will be caused, rather than causing the damage. So we're inspired by all of that. The 2 other things I want to pull out are the 2 thresholds that we've built into the crime. So one is around the gravity of the acts, unlawful or wanton, and the other is around the level of damage, ensuing damage, or damage that is risked, and that is severe and either widespread or long-term. And I'll start with that second one first. So there are 2 legal precedents, actually, 2 obvious legal precedents to draw on here. And one we've heard about quite a lot already, and that is the prohibition that is in Additional Protocol 1 to the Geneva Conventions, and has also been imported in slightly different form to the Rome Statute of the International Criminal Court, and that prohibits widespread, long-term and severe damage. There's another precedent which comes from what's known as the NMOD Convention, which is a convention that prohibits hostile modification of the environment, and that uses the same terms but disjunctive, so severe or widespread or long-lasting. We took a middle course. So we considered that in all cases for an international crime, the damage would have to rise to the level of severe. But we also considered, after much discussion in the panel, that to require it to be both long-lasting and widespread in all circumstances would exclude a number of situations which we thought should be included in the definition of ecocide. So we left those two in the alternative. And then finally, unlawful or wanton acts. If an act's unlawful and there's a risk of that level of damage, then we would have ecocide under our proposed definition. The problem is, as we've heard again and again, that the laws are actually inadequate to protect the environment. So at international level, there are very few concrete prohibitions of environmental damage. And at national level, of course, standards vary very much, and we need a standard that cuts across all nationalities and all jurisdictions for an international crime. So we had to draft a standard that would come in cases that these acts were not already prohibited. And we used the term wanton for this. And I'll move on to the next slide, which is paragraph 2 of the definition. And it's very dense, I warn you already. So you'll see we included a number of definitions, proposed definitions of our term. If you look at the first paragraph, our definition of wanton, so we looked at reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. So what do we mean by that? So we're trying to capture behavior that's clearly not committed for any lawful, legitimate, or useful purpose. And what do I mean? For example, we're not talking about clearing a portion of forest in order to build much-needed housing for a population. I mean, there will be circumstances in which that balance is struck in a way where we accept a certain amount of environmental damage. And in fact, we look to the fundamental principle of international environmental law, the principle of sustainable development, which balances economic, social, and environmental interests together. And we drew upon that for this definition of wanton. And in doing so, we translated it into language which is more familiar to international criminal law or international humanitarian law. So the terms unlawful and wanton appear together in the war crime of pillage or reckless destruction of property, which we thought was an analogous crime. So yeah, that's how we came up with the definition of wanton, and you can see the other definitions, and I'll share a website also in a moment where you can consult later if you want to go into more detail. The final point that I wanted to just draw upon before moving to discuss national crimes in Ukraine is that you'll note no human harm is required to prove the crime. So this is really the revolutionary contribution to the Rome Statute. We do not require human harm to be established in order for that crime, that definition of the crime, to be fulfilled. Now, of course, we assume human harm because we understand increasingly, all of us, the interrelationship of human well-being with the natural world and other living creatures. But a prosecutor does not have to establish human harm, unlike in the crime of crimes against humanity or the crime of genocide, for example, in order to establish our new proposed international crime of ecocide. Thanks, Andrew.
Thank you, Kate, for that very comprehensive run-through the proposed new statute.
There was actually, I was just going to put up the tech team. The very last slide has the website, which people might want to visit for further information on, the definition and an explanation of the definition, as well as numerous other resources are available on that site.
So, Kate, just staying with you on this, Jojo Mehta in her video talked about proposals to introduce a crime of ecocide into national law in various other countries or various countries around the world. What is the significance of Ukraine already having ecocide in its domestic criminal law?
Yeah, I mean, the significance is not just that Ukraine already has it, but that Ukraine is taking this pioneering attitude and implementing it, prosecuting crimes, also in armed conflict. And as a small aside, I should just say legally, there are some complications for prosecuting acts of war under domestic criminal law. So the domestic law, the criminal law, continues to apply throughout this armed conflict, but for lawful combatants, which usually means members of the armed forces, the official armed forces, the application of the laws of war has some permissive effects. So certain acts are permitted in conflict, which would be in contravention of national criminal law. And that's obvious. Obviously, for example, shooting a member of the opposing armed forces would normally be an act of murder, but that would not be prosecuted in an international conflict because the combatant has immunity for certain acts. So just one thing in prosecuting this national crime of ecocide, the prosecutor's office is being careful to ensure that the acts that they select for that prosecution are not permitted, or rather are prohibited by international humanitarian law. So there's a slightly technical legal point I just wanted to share, which the lawyers in the room will be familiar with. But to come back to your main question, what's the significance? The significance is that it's exactly this kind of state practice that's going to be crucial to establishing an international crime. And here I want to come back to a point that was made yesterday by Wayne Jordash in his contribution about prosecuting international crimes. And Wayne he took us back to a time when conflict-related sexual violence was not as widely noted, and not as much attention was paid to that crime. And he noted the way that was surfaced in prosecutions and the effects that that's had. And he drew an analogy with prosecuting environmental crimes, which I think is a really valuable one. Many of these acts may be prohibited already under other laws. So we've heard that they may also be war crimes, targeting civilian objects, or disproportionate attacks of legitimate military attacks, disproportionate effects of legitimate military attacks. They may be able to be prosecuted in this way, but actually what we need to do is name the environmental damage and name the environmental crime. And that's what Ukraine is able to do by prosecuting under its domestic crime of ecocide. It's able to surface those crimes. And we saw in the case of conflict-related sexual violence that had a big knock-on effect. It made it visible. It led not just to more prosecutions, but it led actually to the developments of law and policy. And I think Ukraine is really uniquely positioned to advance this, and it's taking up that mantle. Ukraine not only has the crime, but it has the moral authority, and it has the attention of the world. So it can play a really important part in moving this campaign forward.
Thanks very much indeed, Kit. That's really fascinating, the idea that Ukraine is almost trailblazing in terms of the use of its domestic legislation. And let's see how that goes. Carl Bruch, if we can turn to you, please. Can we talk about other potential legal causes of action and the adoption of a complementary approach in terms of legal remedies? In your opinion, are there other crimes that should be considered or other legal tools? And then following on from that, can you talk a bit about state responsibility for the commission of environmental crimes and or other violations?
Absolutely. Can I have the clicker?
Oh, clicker. Sorry.
Okay, thank you. So I'm going to circle back to some of the presentations from yesterday in particular, because I think that it's important to recognize, even as we are in a pioneering phase with ecocide, and there's kind of a popular understanding of ecocide, and then there's the legal understanding of ecocide. And there are a lot of environmental damages in this war that would not qualify as ecocide. They're still punishable. They're still violations of international law. They may be violations of international criminal law, international humanitarian law, international human rights law. They may be violations of the UN Charter. All of this is to say that there are a lot of violations. Not all of them are criminal. Not all of them are ecocide. And I just want to remember that and kind of circle back to that. And in last year, the International Law Commission finalized their principles on protection of the environment in relation to armed conflicts. And one of the pioneering things that these principles did was that they drew upon a coherent body of law. When I first got into this back in 1997, 98, looking at issues around the environmental damage from the Iraq-Kuwait conflict, most people focused only on international humanitarian law. There was a vigorous debate about whether international environmental law even applied. That debate's gone. We have now, the International Law Commission has said, as long as there's no direct conflict, this is exactly what Kate was talking about, with it's not murder if you're a combatant, generally speaking. That as long as there's no direct conflict between the international law of war, that is to say international humanitarian law, and the other bodies of law continue to apply. And so we're able to bring in a lot of other violations. And I think this is important to note. They'll come up briefly in my presentation, but a few areas, a few different violations. One is we still have, under existing law, long-term widespread and severe damage to the environment. And this is found in a number of treaties and statutes. We have indiscriminate attacks on the environment, particularly on civilian objects. And we saw this actually, it goes back to the Nuremberg trials following World War II. And there were a number of trials for a scorched earth policy that Hitler had called for. And some generals were convicted, some were acquitted. The difference was whether the general reasonably thought that the scorched earth tactics were militarily necessary. So we still have this military necessity element there, but we have well-established precedent that the indiscriminate attacks on civilian objects are prohibited. And then a wonderful recent case out of the special jurisdiction for peace in Colombia on the River Cauca. One of the interesting things there, the plaintiff was nature. It was not the government on behalf of nature. It was not a civil society organization on behalf of nature. The plaintiff was nature. And so that was an interesting development, both legally and from an academic perspective. Another long-standing set of prohibitions are around pillage and looting of natural resources. And I'm not going to go through the treaties, but you see just, treaty after treaty after treaty prohibits pillage. This goes back, in fact, to the Old Testament in Joshua. This is an ancient prohibition. If you're taking resources to advance the war, that's one thing. If you take it for personal benefit, death. And we see, again, decisions, Nuremberg, and more recently on a range of pillage cases, as well as the national court decisions. And so I think it's important to note that and I've heard a number of examples, not so much here, but actually before coming here, about timber and other resources that have been taken from eastern part of the country that would be clear violations of the law of pillage. There are also other legal causes of action. We saw with the Special Court for Sierra Leone, both in the RUF cases and with the prosecutor v. Taylor, prosecution for slavery, for torture, for a variety of crimes against humanity that were associated with the extraction of diamonds. And so the context and all the things that are associated with the context can be prosecuted, even if the context, the prosecutors struggled. And I think that there's been, this is part of the evolution over the last 25 years, that we could see the environment being affected and being a driver, but politically there's often struggles in how do we actually prosecute these violations. We also see a number of prohibitions against attacks on works and installations that contain dangerous forces, dams and nuclear power plants. We've heard a number of a whole panel on the Kakhovka Dam, but also I think both with Chernobyl and Zaporizhzhia, there are clear violations of international law. One of the interesting things is that there is precedent already with the Eritrea-Ethiopia Tribunal, which said that an attack on a reservoir, I think this was brought up yesterday, the attack on a reservoir was a violation of Additional Protocol 2. No damages were awarded, though, because there was no economic harm that was shown. So, but there was a clear statement that this was a violation of Additional Protocol 2. And then objects indispensable to the civilian population. I think this is important both in terms of starvation, but then in terms of attacks on drinking water installations and supplies. And finally, in support of genocide, we saw a charge against Omar al-Bashir on genocide, supporting evidence was the poisoning of wells. This part of the genocide claim was ultimately tossed out, but it does show that the connections to the environment can not only be prosecuted under environmental provisions, but under other provisions of existing international criminal law and international humanitarian law. The final crime or the final violation that I want to note was the crime of aggression. And this is really interesting because the questions of, well, does it meet the threshold of long-term? Does it meet the threshold of widespread or severe? You don't have to worry about that. And we'll get into this in a moment with the UN Compensation Commission. But basically, what we saw with UN Security Council Resolution 687, which set up the UN Compensation Commission, that when a country violates UN Charter Article 2, Paragraph 4, which prohibits illegal aggressive warfare, there's an obligation, a state obligation, to make full reparation. Colin Powell called it the Pottery Barn Doctrine. You break it, you buy it. It didn't matter if it met, these thresholds. It was a question of what were the damages coming from this wrongful action, getting the scientific evaluation of that, the economic valuation, and getting payment on that. And we've seen three precedents for this. With the UN Compensation Commission, the case between the Democratic Republic of the Congo and Uganda before the International Court of Justice, and the Eritrea-Ethiopia Claims Tribunal. Before jumping momentarily to the UNCC and lessons from that, I wanted to note that the Rome Statute, we think about international criminal law and the Rome Statute, and there's imprisonment. What I find interesting is these other remedies that are provided for in the Rome Statute, including fines, forfeiture of proceeds, and reparations to victims. Again, this is, by individuals, so you have to have an individual that has sufficient wealth. But this is something that just to keep in mind, that with the right defendant, think beyond just imprisonment. So the UN Compensation Commission I mentioned held Iraq responsible, or I should say the UN Security Council held Iraq responsible for all the damages, including damages to the environment and natural resources, as a result of the illegal invasion, created the UN Compensation Commission. Importantly, this was funded by a tax, if you will, on oil sales coming from Iraq. That all the payments that were due were concluded, finally paid January of last year. One of the things that I think is interesting is that liability was presumed. There was no question about liability. It was all a question of, can you show what the damages were, and was there a reasonable valuation of those damages? And so I think that Yuri did a fantastic job highlighting a number of these points yesterday. There were $85 billion in claims, $5 billion awarded. In a number of cases, the sorry, I should be clear. The insufficient evidence of loss and insufficient causal link, that was not a reduction. That was, the claims were tossed out. They were rejected. The reduction in amounts, or the downward adjustment, it was when they weren't able to show baseline data. So the difficulty in Iraq, or in Kuwait, was that you had oil exploration for a long period of time, and that had some pollution. So how do you distinguish the pollution from the war, which Iraq had to pay, from the pre-existing damage from the oil development? So the question is, how do you kind of show that baseline? And I think one of the great things that Ukraine has been able to do was that very early on, you started collecting data on what the situation was and what the damages were. So I think there's a much greater body of evidence. There's also, one of the things that we saw was that damages, or claims for compensation for remediation were generally awarded in full or mostly in full, where claims for damages that were not addressed, not remediated, not actually incurred as costs, those tended to be reduced. So I think it's important to note, whatever you can do now, A, do it, and B, keep the receipts, to show the evidence that this is how much you spent on doing it. And this is not just the remediation, it's also on tracking public health, on doing the monitoring, on the evaluation. Those are also compensable damages. I think another point that Yuri made very clearly was the importance of making sure that the valuation methodologies that you use are widely accepted. And being careful, and Kuwait, I think, had about 23% of its damages, of its claims awarded. Iran had less than 1%. So, these are very different questions of methodology, but being very careful not to overclaim, because that can get a court or tribunal responding very negatively. We saw this with the Eritrea-Ethiopia Claims Tribunal, where there were $1 billion in environmental damages claimed and practically none awarded. So I think it's important not to be overly ambitious, if you will. A couple of lessons. First, it is important to note that this is not the first time we've seen environmental harm. It's not the first time that there have been efforts to hold people accountable. There are a growing number of institutions and a growing number of cases that hold both states and individuals accountable for wartime environmental damage, both criminal and financial. And I think it's important to kind of look at these precedents, because when it's the first time something's done, people look at it very carefully. When it's the third, fourth, fifth time, this is normal. This is just making sure that we follow the rule of law. Second, there are multiple legal pathways, and we should not choose just one. On the criminal side, yes, let's look at ecocide, but let's also look at all these other crimes. Similarly, even while we pursue criminal, let's work on pursuing the financial side. And I think that there's a clear legal basis and precedent for financial accountability for the environmental damage. The real question, from my perspective, is a question of politics and political will. And I think that there are definitely legal questions about how to do it and how to do it better. But the question of whether you can do it, I think that's fairly clear. I think one of the things that it does highlight, though, is really the need to secure the assets. With Iraq, you had a flow of money coming out of the oil sales. For Russia, the greatest point of leverage is in the frozen assets. And there is a vigorous debate going on right now about whether countries may, under international law, seize those assets. or whether I've seen some analyses that say, well, you need to have the Security Council or the ICJ do it, otherwise it's illegal. And I think Lawrence Tribe, he just published a fantastic report last month, 200 pages, basically showing why that's not so. And there were, I believe, 7 examples where the U.S. already has seized assets from a country to help pay compensation to victims out of the Lockerbie bombing from Afghanistan, Iraq, and other countries. And so I think that there's precedent here, and we need to look at this and move on it. I think there's a question about what we seek compensation for. What's the institution? And I realize I'm running out of time, so I'll just say that there are some very interesting discussions around this, but the more international it can be, the more countries that support this. I don't think that it's going to happen through the UN Security Council or with their blessing, whether it happens with the UN General Assembly or through a coalition of like-minded countries. I think one thing that is important here is envisioning how to create a space for Russia to participate. And this was something that happened with the UN Compensation Commission. And at first, Russia said, Iraq said, we're not going to participate. This is not a legitimate exercise. And then they saw, well, maybe actually there's something in it for us. They did participate. They did challenge some of the assertions. And on a number of points, they won. And so I think that even if Russia doesn't agree with it, there will be financial incentives for them to actually participate. And the question is making sure that that is there, because the more there is a contested space, the more legitimate it will be. And I think that will help not only with this case, but with the accountability for wartime environmental damage writ large. Thank you.
Carl, thank you so much for that. That was a really terrific... a really terrific examination and run through the much wider scope of potential legal causes of action, and you really sort of set it out there very clearly and very detailed, so grateful for that. Nabil, if we can turn to you, please. You are approaching the subject of pathways to accountability more as a scientist as opposed to being a lawyer, and you have been working with the Office of the Prosecutor General I think, to build a platform to assist in accountability and in the gathering of data and presentation of data when it comes to environmental war crimes. Could you explain in a bit more detail the work that you've been conducting on this?
Sure, thank you. The slides are already there.
Yeah.
Wait, yeah. Hi, everyone. Thank you for the invitation to participate in this important conference to the Office of the General Prosecutor. I'd like to start by, we heard about the Nuremberg trials, but just to take a step back and look at that from a different point of view. We've all heard the expression that a picture is worth 1,000 words. Sitting in courtroom 600 in Nuremberg, perhaps no one was more acutely aware of this notion than Hermann Göring, who, after the screening of the documentary film by the prosecution of the first images brought back from the concentration camps, said, and I quote, "And then they showed that awful film, and it just spoiled everything," end quote. What makes the war in Ukraine particular is that it's also a war of 1,000 images. With the vast amount of image data collected by Ukrainian investigators, but also open source intelligence community, civil society organizations, and the public. But here's the thing. 1,000 images, when considered together, are no longer just images, but also data. Add to that what Victoria Litvinokova, Deputy Prosecutor General, yesterday called the evidentiary peculiarities of environmental damage. Right, means dealing with the representation of temporal and spatial scales involved with, for example, the terms that we've heard quite a lot these past since yesterday, widespread, long-term, severe. And also find ways to make visible and audible types of violence that are slow, silent, invisible, and that escape the threshold of detectability. Gathering and presenting forensic evidence of environmental war crimes, then, might require new strategies and tools. As we've heard, there are a range of legal protections granted to the environment during armed conflict that the OPG and its partners are pursuing under a set of prosecutorial platforms, from national laws, international laws, to those afforded under universal jurisdiction. So one of the possible next steps for ensuring an end to impunity for related environmental damage in Ukraine, identified by the OPG, is an online digital platform of forensic reconstruction of attacks that can first help strategic partners, civil society, and the public better appreciate the nature and scale of the environmental war crimes caused by Russia's war of aggression and the work done by the OPG to address these crimes. And second, also provide prosecutors with visual aids, and in some instances evidence, that may be adduced before courts in the prosecutions of environmental war crimes. So think of the platform then as a tool, right, that can visualize complex scientific data, that can take the user to scenes of crimes using satellite images and 3D models. And being digital and online, it can of course help in raising awareness nationally and internationally of Russia's insidious attack on Ukraine's environment, and by extension of Russia's crime, perhaps that amounts to ecocide. In terms of methodology, we can design such a tool to synthesize disparate kinds of data: documents, narrative accounts, photos, videos, maps, satellite images, environmental data, soil, air, water toxicity mapping, social media reports, ground truth, and forensic reports, and undertake additional investigations in collaboration with scientists and the authorities and civil society organizations. And at its core, we could consider having things like interactive maps, timelines, explanatory videos, and 3D models that can help animate and visualize complex crime scenes and associated facts. To give a quick example, 3D environments that can use a combination of satellite images, existing digital elevation data, photogrammetry derived from aerial drone footage, which are used extensively in this war, 3D modeling software and game engine technology that can deal with things like resolution, in which visual evidence and scientific data can be placed together, creating seamless movements between places, events, actors, and data. Here's an example of a case where we built a 3D environment of a disputed territory in Norway where Sami reindeer herders are fighting a wind energy company in a civil proceeding to include their point of view and drone footage that they acquired of what they consider to be matters from the dispute. At the same time, case files, such as the Kakhovka Dam, could help prosecutors expose and create a broader narrative, highlighting the horrific nature and scale of the crimes and their invisible dimensions. For example, pollution pathways in air, and soil and water. Now, there are a few examples that we could look at of such platforms, specifically in the context of international criminal law. Here's an ICC platform, Mali platform, developed by C2 Studio in collaboration with the ICC's Office of the Prosecutor for the Al-Mahdi case. Here, Al-Mahdi was an alleged member of the Ansar ad-Din, a movement associated with Al-Qaeda, who was accused of war crimes, consisting of intentionally directing attacks against religious and historic buildings in Timbuktu, Mali. The interactive platform was designed to facilitate the organization, the analysis, and the presentation of evidence documenting the destruction of sites of cultural heritage in Timbuktu. Actually, the platform wasn't really used as evidence in the court in the case because Al-Mahdi pleaded guilty as a co-perpetrator of the attack. making it the first international trial focusing not only on the destruction of the historical and religious monuments, but also the first ICC case where the defendant made an admission of guilt. Interpret, in collaboration with Climate Council, recently designed a Brazil crimes platform to support an Article 15 communication to the ICC. The communication was filed by the Climate Council in conjunction with Greenpeace Brazil and other organizations on behalf of rural land users and defenders who are victims of the alleged crimes against humanity. The communication also demonstrated that over the last decade, a widespread or systematic attack has been committed against rural land users and defenders, including crimes of murder, persecution, and other inhumane acts. This attack was committed pursuant to an organizational policy from Brazil's government, which intensified under the Bolsonaro administration to facilitate the dispossession of land, the exploitation of natural resources, and the destruction of the environment. The platform facilitated the ICC communication, supported it by bringing together disparate forms of evidence, including photographs, testimonies from survivors and family members of victims, 3D reconstruction of crime scenes and forensic evidence, visualizations of data collected by the Comissário Pastoral de Terra, or the CPT, between 2011 and 2021, which formed the backbone of the evidence of attacks that fits crimes against humanity, and also drone footage, satellite imagery analysis, deforestation, and forest fire data of the Amazon that actually made the case of the interests of justice as to why the ICC should take out such a case, because it is for the benefit of the whole world to protect something that is important as the Amazon. So, of course, in this case, the ICC is just one potential avenue for accountability in Brazil. The evidence contained in the communication will be used to pursue forms of justice in a range of judicial, legal, and diplomatic fora. At the same time, the platform also helped, and the communication, helped Brazilian civil society organizations and victim groups to better understand the links between environmental destruction in the Amazon and crimes against humanity under the Rome Statute. In the end, ladies and gentlemen, I'd like to leave you with sort of three thoughts of how such a platform could first provide a visual overview of the vast array of evidence required to fight environmental crimes as we see today unfolding in Ukraine. It can also raise awareness globally to help people see the slow violence of Russia's war of aggression and its impact on the environment. And also, finally, that we need new laws such as ecocide. We need new imaginaries to make ecocide an international crime that this can help to achieve. Thank you very much.
Thank you very much indeed, Nabil. That was really interesting, seeing the practicalities of those previous investigations and the steps you took and how it was spatially mapped. I see that we're at 5 minutes past 2. I'm not sure if the organisers are allowing us question time, or are we? Okay. Right. Okay. So I think you've heard from what we can regard as 4 true experts here who've really set out their field of knowledge in such a methodical and clear way, and certainly I feel very much more enlightened than an hour ago. So thank you so much indeed.
Thank you very much, Mr. Carney. Thank you very much, distinguished speakers. The path to finding and holding those responsible for war crimes against Ukrainian nature can be quite long, and maybe at some point we might go in wrong direction, but no matter what, finding that right path can be accomplished only by traversing different roads. And I want to thank all international experts and decision makers who helped the international community move forward this path. Because as for me, the most important thing is not to stop halfway and not to allow guilty to escape responsibility, because that's exactly what they are counting on.